Hi, my name is Gokul Narayan and I'm the lead faculty at the Asian School of Cyber Laws. And in this video, we're going to be discussing the Diploma in Cyber Law program and its details. To begin with, this program has been divided into 4 distinct parts: the fundamentals of cyber law, e-commerce and legal issues, intellectual property rights in cyberspace, and cybercrime law in India. These are the 4 components that comprise of this course. Let us have a look at each and every one of these components individually. So, the first component of the fundamentals of cyber law is the introduction to cyber law. Now, as the name itself suggests, this component talks about what cyber law is, what's the need for cyber law, the chronological events that took place in the development of this law from its initiation to its current status, and last but not the least, some important terms and concepts that we've discussed. In this, we also discuss aspects relating to differentiating concepts which are virtual with that of what happens in the real world. For example, differentiating between the idea of access, which is a virtual concept, in comparison to trespass, which is a real idea. Second component of this section is the legislative framework within which this entire field functions. And we begin with an introduction to the most important part of this, which is the Information Technology Act. After the Information Technology Act, it throws light on the ancillary laws which are also concerned with the Information Technology Act and have a direct impact on this field, like the Indian Penal Code, the Indian Evidence Act, the Bankers Book Evidence Act, the Code of Criminal Procedure, and the Payments and Settlements Act. Components 3 and 4 talk about the judicial and the quasi-judicial framework within which this law functions. Now, the Information Technology Act has been divided into 2 distinct parts: the part which concerns itself with civil provisions and the part which concerns itself with penal provisions. Now, the Information Technology Act has been drafted in such a manner that it has ensured that the regular civil courts are not overburdened with cases relating to information technology, and special authorities have been created to deal with this issue. This section talks about these authorities. On the civil side, who these authorities are, like the adjudication officer, who does the appeal go to, and how does it land up with the High Court eventually. And on the criminal side, it also talks about what the framework of the judicial system will be in dealing with aspects that arise on the penal side. Last but not the least, it talks about the certifying authorities. It's a special body and an authority which has been created to specifically deal with issues relating to digital signatures, digital signature certificates, and ancillary issues like this. It is one of the most important authorities that have been created under the Act and has been given immense powers under this Act, which you will find out in this component. The next component is the investigative framework within which this law functions. This talks about the powers of the investigation authority, mainly the police, how and when they can investigate, and what are the restrictions within which they exercise their powers. The next component talks about related issues. Here we discuss issues like details of the certifying authority, details of intermediaries, who are intermediaries, what do intermediaries do, what laws, rules, and regulations are they subject to, and what case laws do we have to understand the framework within which they are expected to function. We also talk about offenses by companies over here. For example, if there is an organization which commits a breach of any of the provisions of the information technology law, what is the liability that the company faces in this regard is what this component features. This component also talks about using digital signatures as evidence. By this I mean, if a digital signature which has been issued by an individual needs to be produced in a court of law as evidence, what are the rules and regulations which will be required to be complied with for doing this. The next component talks about the international framework within which the Information Technology Act is expected to function. It throws light on international treaties, rules and regulations which form the basic framework of the international space within which the Information Technology Act in India has to function. Now, why is this relevant and how is this important? This is because the Information Technology Act primarily deals with the virtual world. It's a world which does not understand boundaries like the physical world, and therefore international treaties of cooperation become extremely important for understanding Information Technology Act in a holistic sense. The last component of this section is basic terms and terminologies which we want our audience to be familiar with. These include concepts like what is evidence, what is double jeopardy. We have chosen some words to explain primarily because some of our audience also belongs to the non-legal fraternity. This will help them understand basic terms and terminologies which they need to acquaint themselves with to appreciate this course material better. The second component of this course is the e-commerce and legal issues. This is further divided into 4 separate sections. We start off with an introduction to the e-commerce world. What does the e-commerce world look like today? How has it progressed over the years? And what does the future look like? The second component of this section is the digital signatures technical issues. This talks about concepts relating to digital signatures, their applicability, the different concepts relating to digital signatures like cryptography, asymmetric cryptography, hash functions, and so on and so forth. The idea basically is to give the audience a basic understanding of the use and application of digital signatures in the current technical scenario. The third component of this section is electronic signatures and their legal issues. The previous section covered the technical issues, and in this section we talk about the legal issues, which primarily revolve around the idea of how digital signatures function, what are the authorities connected with the application and use of digital signatures, how does the law protect the use and therefore the misuse of digital signatures, and what are the consequences of this misuse. And it also tries to explain the framework within which electronic signatures and digital signatures function. It also tries to explain to the audience what the difference between an electronic signature and a digital signature is. The last component of this section is the concept of electronic contracts. Now, electronic contracts talk about the application of contracts in the electronic world. It does not recreate the basic concept of contracts which have been discussed under the Contracts Act, that of acceptance, offer, and so on and so forth. What it does try to talk about is how do these concepts translate into the virtual world? What is the difference between an offer which is made virtually as opposed to an offer which is made in a physical form? It therefore talks about the application of electronic contracts in the virtual world and tries to distinguish between various kinds of contracts that one enters into. Like, for example, when you're installing a software, one of the most common forms of contracts that all of us have to enter into are known as click-wrap agreements. Now, these are agreements which, after the installation of the software, there is a button that you click which says, I accept the terms and conditions mentioned herefore. This basically is the entering into a contract between you and the person who's providing the service in the form of the software or the website that you're using. This section talks about contracts like this and many more. The next section talks about intellectual property rights in cyberspace from the Indian legal perspective. We begin this section with a component relating to the introduction of intellectual property. What is intellectual property? What role does it play in cyberspace? What importance does it have in the concept relating to information technology, and how does it correlate with each other? After this, we move into the most important part of intellectual property in cyberspace, that being copyright. This section talks about what copyright is generally, not from a virtual perspective, but in the real world as well. Works of literature, sound recordings, cinematographic films, and the various forms of copyright and their application. The laws and regulations within which they function, the duration of copyright, the different forms of copyright, the rights and rules and regulations associated with copyrights, and so on and so forth. The next two sections talk about the application of copyright in the field of computer software. India and the rest of the world, barring the United States of America, put software as a component of copyright. The United States of America, on the other hand, for some reason, puts it under patent law. Having said this, these two components talk about what computer softwares are, how are they brought within the ambit of copyright, because actually what we are putting it under is works of literature. And this component explains to you how computer software can be treated as works of literature and be protected under copyright law. the different kinds of licenses that exist, the different laws, rules, and regulations that govern this field, and their application in the virtual world. The next component talks about types of software licenses: freeware, adware, open source licenses, proprietary licenses, the difference between open source and proprietary licenses, general public licenses. These are all licenses which we actually use on a day-to-day basis but are not familiar with. The objective of this section, therefore, is to familiarize the audience with these various kinds of licenses and what the difference between each of them is. The next section talks about computer databases and the law. We today live in a virtual world where information relating to prospective and current and past clients happens to be one of the most important intellectual property that people own. And therefore, the protection of this intellectual property becomes extremely important. This section talks about the laws relating to databases, their need, their application, their understanding, and the fallacies that exist in this field. This section shifts focus from copyright to trademark law. And under trademark law, it specifically focuses on domain name disputes and issues arising out of the use of domain name in the virtual space. Now, there is a specific law that has been drafted for dealing with issues arising out of the use or misuse of domain names. However, the existing trademark law also governs this field. This section throws light on both these components and the problems that arise out of the dual nature of laws governing this field. Next, under trademark law, we deal with issues relating to meta tags, framing, and deep hyperlinking. These are issues which are specific only to cyberspace. For example, if there is an individual who wants to direct herself or himself from a search engine to a proposed destination website, how does this transfer actually happen? In this context, what are meta tags? What are description tags? And what do they have to do with trademarks which can be misused online? The last component of this section is semiconductors and design layouts. Now, although this part actually is slightly technical in nature, it is still very relevant for us to understand it in the context of the current scenario, because with the advent of technology over the years, our computers and our electronic devices have become smaller, more compact, but with far more capability than we had earlier. Just to understand this, try and compare a laptop that you saw in the early part of the 2000s to a laptop that you see today. They generally are a lot lighter, a lot smaller, and have a lot more processing capability with larger battery life. Now, this is all possible because of the semiconductor layout, which governs the size of the electronic devices we use. The semiconductors have become smaller and have been able to achieve a lot more in a compact space. And therefore, this law talks about the semiconductor and designs and layout system which governs this field. The last section of this course deals with cybercrime law in India. Although this section is called cybercrime law in India, it deals not only with cyber crimes from a penal perspective, but also from a civil perspective. Chapter 9 of the Information Technology Act, as you must be aware by now, deals with civil contraventions, and Chapter 11 deals with penal offenses. This section deals with both these ideas in terms of how do we legally interpret the sections relating to civil contraventions as opposed to the penal offenses that we have under the Act. It deals with various components of civil contraventions like acts which are done unauthorizedly, including unauthorized access, unauthorized downloading, unauthorized introduction of computer contaminants and viruses, unauthorized damaging of content, unauthorized disruption of services, denial of service, abetting other individuals for facilitating the commission of a contravention or an offense, credit card frauds, disrupting or damaging computer parts or components, and last but not the least, affecting computer source codes and programs adversely. This is the civil part of this section. The next part of this section is the penal offenses under the Act, which start off with section 66A, which talks about freedom of speech and expression, but this section has already been repealed. It then goes on to procuring contents illegally, computer devices, electronic devices, communication devices illegally, cheating by personation or impersonating another individual, issues relating to privacy of the human body, and cyber terrorism. The next component of this section talks about offenses relating to privacy more specifically, like pornography, sexually explicit acts, sexually explicit conduct, the rules and regulations relating to the prohibition or use of child pornography, and then goes on to aspects relating to blocking of content for public view. These are more application-oriented sections which talk about how the government and its agencies can maintain control over what is happening in cyberspace. It goes into issues relating to breach of confidentiality and privacy between employees and employers, wherein an employee reveals to a third party information that has been made privy to her or him as a part of the job. What is the ramification of such a breach? It talks about issues relating to compounding of offenses, abetment in commission of crimes, authorities which have been created under the acts, apart from the ones which have been already discussed in the previous parts, authorities like the computer emergency response teams, nodal officers, the rules and regulations governing such nodal officers, and so on and so forth. This section is the meatiest part of this course because it deals with cyber crimes and their application and the problems that are faced with authorities in controlling this field. It is also one of the most important components from the perspective of the examination. This basically is what we cover in the Information Technology Law program, or what is referred to as the Diploma in Cyber Law course. So thank you for watching this video, and I hope the questions that you had at the beginning of this video in terms of what we cover in this program have been sufficiently answered. However, in the remote possibility that they've not been answered, please feel free either to leave a comment below or write into us and we will get back to you. Hope to see you in the course.